Brought to you by Squarespace.
We should leave that in. Maybe we'll get a sponsorship. What would you want to be? I'd want to be sponsored by Neptune Cigars.
Do you want to film a commercial for Neptune Cigars right now and send it to them?
Let's take a trip down to the humidor. We keep getting good witness testimony. Like the case is getting better every year.
If they make the wrong mistake, their firm is done.
You know that. You know I'm right.
I know you're right, but let's say this.
So everybody in the world has a podcast. And part of me feels like an asshole because I don't have a podcast. Like, dude, you have all these subscribers wanting to have a podcast. On the other side, I just don't want to have a podcast because everyone has a podcast.
The world doesn't need more podcasts.
I agree. I completely agree. But people in the comments, my comments, are always asking for longer content. And we've mentioned this case that we're going to talk about today, which was the $7.75 million slip and fall case. And a lot of people want to know the details. So I have to start, though, by telling everyone there are certain things we're not allowed to talk about. Those things I'm not allowed to talk about are really important, and we want to make sure that we're on the same page, and we want to be transparent with everyone out there about why we can't say certain things. So, Stokes, will you remind me, and let's get it all out there, can you tell us the things we're not allowed to talk about?
We're not allowed to talk about who the defendant was.
So we're going to call the defendant or the store.
Right.
Because we're not even allowed to say what business they're in, how big or small they are, right?
Correct.
Okay.
And we're not allowed to talk about any of their insurance companies, who they are.
Yep. Can't say like, screw Allstate like I do in most videos.
It's not Allstate.
Yeah, we're safe on that. We're safe on that.
We can't talk about who the lawyers or the law firm is that represented the defendants.
Which is weird. I've never had a settlement like that.
I can't remember one.
Yeah, this is a case where I can think of 5 cases off the top of my head that wherever we were, whether it was at court, whether it was in the hallway of our building, whether you were in the bathroom, which is how you found out about this case. We made a little video about that. We're jumping up and down and like saying this is amazing. And we are like so happy. It's not every day. It's not every month that we're jumping and screaming and like, being excited in our office about a settlement. This is one of them. So this is one that I think $7.75 million was a very, very good number.
Yeah.
Let's start about how we got this case.
Okay.
This was 2018.
2018.
I get a call from a lawyer friend of mine who's also a mediator, and he says, I have this crazy case for you. Are you interested? Now, the Rafey Law Firm has been in existence in 2018 for 3 years. I think that's right.
2 to 3.
How long had you been working?
I had started 3 months before this case came in.
Yeah, so we had 4 lawyers. I'm pretty sure we had 3 or 4 staff members. So we were 7 or 8 people pretty much at the beginning of this. And at the time, for better or worse, I specialized in crazy cases with high damages.
Cases that other people wouldn't take, but were, if you won, very valuable.
Yeah, because I found it was a lot easier to get cases where people had very significant injuries, permanent injuries or death. Even if there were these huge challenges, it was easier to get those cases as a lawyer to work on them than it was to get a small, easy car crash case. So this case, I remember the lawyer starting and telling me, there's a fall at a store. We think that his doctor committed medical malpractice and as a result, he died. And I said, well, okay, so it's a medical malpractice case. And he goes, no, it's not. I'm like, what do you mean? He goes, well, our thought is that the store caused him to fall. And if the doctor or whatever reason he didn't survive the surgery that he needed, the treatment that he needed, that's because he fell, not because of the doctor. And I remember giving him like the So then you reminded me of this. I then get to the office.
And I think we're trying to figure out some validation to your initial thoughts.
Confidence, all-time high.
Yeah. and you had an idea of what you liked about the case and what you didn't like about the case. And you said, hey, Stokes, come into my office. Let me show you something. And you show me the video. And you said, what do you think? Didn't tell me anything else. And I said, well, it seems like he slipped and fell in this store. And it seems like there was obviously something on the ground in front of him. He's pushing his cart.
Yeah.
And he can't see it. I don't hate that case. I asked you what the injuries are. And you said he passed away. And my jaw just hit the floor. I was like, but no. I just saw the video. He fell.
Doesn't make any sense.
That doesn't make any sense. Then we went through the fact that he'd had a surgery, that he needed because of this fall. He needed another surgery, and then he died from complications of that second surgery.
Well, you say that now because that's been programmed in. He died as a result of the second surgery.
Correct.
We didn't know at the time, still don't know, if it was complications of the surgery.
Yeah, I go back and forth on that a lot. I don't know. I'm not a doctor. But our client was in his 50s, and he'd had some pretty significant treatment on his back and knees and various parts of his body throughout his life because he had been in the military. And the story of how this happened is kind of hazy because at the end of the day, we never met our client.
Right.
The lawyers who referred us the case did because he had a case prior to passing after his fall, but we never got to meet him. So we never got to ask him these questions about how this happened. We had our client was his wife, who was one of my favorite clients that we've ever had. Her husband lived a significant life before they met. And so she didn't have all the answers to all these questions. But at some point, there was something in a record that said that he had some abdominal issues from some sort of shrapnel in the military.
Yeah. So I feel like I should mention our client was Muslim and served in the United States military and, protected our rights and freedom. And I don't mean that condescending towards him. I mean that condescending towards all the people that think differently of people. But being a Muslim in certain places in Georgia and having the case be about a Muslim in the first conversation talking about the case,
we thought about it.
But anyway, sorry, you're at the shrapnel.
Yeah. So he also had a previous low back surgery, and he'd had previous pain in his knees from being mugged when he was younger. I think he got hit with a baseball bat. Having a client who hurt their knees and hurt their low back in a fall with that type of history is problematic from a what are we going to do about this case perspective at the start. So he falls. Then he does everything that he possibly can to not have to have a surgery. Yeah. So many defense lawyers want to throw people and plaintiffs under the bus and say they didn't do everything that they were supposed to do to get better.
Bro, but if they did too much, they're milking it and over-treating.
Yeah. So you've got to walk that line, I guess, which is impossible to do.
If you're hurt out there, just do what your doctor says.
Right.
And get a second opinion.
Right.
That's it.
And that's what our client did here. Yeah. Went to a doctor, got some conservative treatment, told them.
When you say conservative treatment, you mean like PT, physical therapy.
Physical therapy. Yeah. Had an injection or two in his spine.
An injection to numb the pain.
Right.
I'm trying to make this accessible to everyone. So know what the heck you're talking about.
And he told his doctors, most importantly, about his previous history with back pain.
Yeah. Because he got hurt more than you and I would have. If you and I fall, I'm firmly convinced, in the same way that he did, if we fall like that, we walk out of it. I finish shopping, I'm embarrassed. Maybe I don't finish shopping. Maybe I run out of the store because I'm embarrassed, but I'm okay, right?
Right. But for somebody whose spine has so many problems with it already and is so delicate, it's not going to be something that they can walk away from. And that wasn't what he had. So he goes to a doctor to get physical therapy, to get some injections, tells them everything about how he was before this fall.
Yeah.
That doesn't work. So then he goes somewhere else. And he says, I don't want to have surgery. I've had surgery before. Do you think I need surgery? Doctor says, no, I think you'd benefit from more conservative treatment.
Which that's what every doctor is going to say to you if you go, I don't want surgery. They're like, yep, go to PT.
Right.
Like that is the default answer.
Our client wasn't, from the records, doesn't seem particularly happy with that response because the conservative treatment he was recommended to go get was the same thing that he'd already been doing.
Yeah.
So he goes somewhere else to get a second opinion. And the doctor says, I think you'd benefit from more conservative treatment. Here's somebody that you can go to that will look at all of the options based on what you've already got. So our client does that very thing. Doctor number 4 says, the only possible thing we can do is this other type of injection that's at this point in your back. It's not what you've gotten before. And you're not getting any better from any of these things. If you don't get better from this, I'm going to send you back to a surgeon.
Doctors eventually say, hey, you need to have this surgery. And he has that surgery and it's not successful.
Right.
And then talk about the second one, because that's obviously
the second surgery is a little bit more invasive in that it took some of the hardware that he'd had from before the fall and the hardware that was newly placed, and it just kind of took it out and replaced it into one big bracket.
He never leaves the hospital after the second surgery.
Correct.
Yeah.
He's there for a few weeks. And
which was not the plan, right? No. He should have been out of there in a couple of days.
Yeah.
Yeah.
And what's important is for this type of surgery, they went through his abdomen to access his spine. The complication that he developed was a combination of things depending on which doctor you ask. But all of the doctors point to the fact that it was caused by the surgery. Not that they knew this was going to happen when the surgery was recommended or that he shouldn't have been recommended the surgery, but surgery is dangerous.
So we got to talk about it. The meeting. We got to talk about the meeting. So I think we've agreed to take the case at this point, but we're still like, at least I'm still sort of in the house, but I'm also 1 foot out the door. You know, like I'm still ready to run. So we schedule a meeting with the treating surgeon, the one who performed the 2 surgeries. And the purpose of the meeting was literally to ask him, because we expected the store and their lawyers to say, this wasn't us, this was malpractice. This was medical malpractice caused by the surgeon. That's why your client passed away. So we had identified that very early on, and we wanted to talk to the surgeon. So we scheduled a meeting with the surgeon. You're looking at me and I'm looking at you right now making a face because it was one of the weirdest meetings I've ever had. Like ever. And most uncomfortable, awkward meeting. I expected to go there and say, and I remember we had an affidavit that we had written with the doctor that was the bare bones. It said, I'm so-and-so. I performed this surgery. My patient died as a result of the complications to the surgery. And then we had a blank space, I'm pretty sure, of what the complications were, because that's what we wanted to know. Why did he die? Can you tell the people watching this why he died right now? Can you do that?
I can tell you what medical records and what doctors have said, but I don't know.
I can't. I don't even know if I walked out of that meeting. I don't think we ever got a clear answer.
We did not, let's say, we did not have that statement we had prepared bare bones for him signed when we left.
Yeah, so we walk in, we go to the doctor's office. We schedule an in-person meeting. And I remember showing up and expecting just to go into the doctor's office and him sit down, have a casual but honest conversation about what happened. And that was not what happened. We are escorted to a conference room. He had what? Who did he have there?
There was no one around. Like the area where we were escorted to had no one near it.
Yeah, they evacuated the area so that no one would ever hear this conversation.
Right. The door closes and every question about...
Well, wait, who's there? There's his practice manager.
The practice manager let us in. There was a lawyer for the practice that was kind of was not in the meeting, but was kind of like walking around the office. And we only learned that that's who she was when the doctor referenced her as, okay, well, she'll have to look at whatever statement you want me to sign. And that was weird.
I've never had that happen ever, before or since. The doctor was literally like wearing a sign on his forehead that said, I probably committed malpractice. Like that's how I walked out of there. I remember we got into the parking lot and I said to you, yeah, he killed him. That's what I said. That's what I said.
This is where we fundamentally disagree.
Dude,
and I will tell you this.
That doctor was hiding. Can we agree he was hiding something?
I'll tell you what I think. I don't know if the doctor's hiding anything.
You think
You
think too much of people.
I think that he was scared of a lawsuit. And I think he was scared of a lawsuit in that the way that our client died was so complex and was so disputed, even amongst doctors in the case, that he was afraid about how it would look and whether or not he would be able to convince people that he didn't mess up.
But we purposely went to him after. I remember we waited and went to him 2 years after the surgery. I remember I started the conversation by saying, we don't think this is malpractice. At that time, I did not believe that, but I was obviously going to say that to him to get him to participate with us. So I said, hey, we're not looking at this in any medical malpractice way. In fact, we can't because the statute of limitations is already run. You would think I'm like, hey, take this layup, like dunk the ball. And he was not willing to be specific in any way. I mean, we walked out of there, or before we walked out, I said, like, what would you attribute the death to? And he was just like, complications. Okay, what complications? To date, I still cannot answer that. But that doctor was literally like, if a cop came up to you on the street and you said, I didn't do it, officer. It wasn't me. Like, that's what that doctor was like. And you know I'm right.
I know you're right, but let's say this. Some people who say I didn't do it, officer, also didn't do it. So,
dude, we were not the cops though. We were there like, hey, we're trying to help our client. We don't think you did anything wrong. And he's like, yeah, I didn't do anything wrong. I didn't do that. Like, that guy who we have not had any clients go to since, I don't think, right?
I think we've had some clients go to a colleague or two of his who have had a lot of success.
Yeah, and he's known, this doctor that we're kind of on here is known as a very good surgeon.
Right. Every doctor in the case said that he was someone that they refer clients to.
Yeah.
There's a possibility that he's just a nervous gentleman.
Maybe. All right, so when we first get the case, it is in federal court.
No.
What?
When we first get the case, we have the wrong manager. When you sue a store, one of the ways in which you can ensure that you're in state court, which is there are federal courts and there are state courts. State courts are in specific counties, at least in Georgia. And you like to be in state court in Georgia, depending on what area of the state you're in, especially, like we talked about earlier, when we have a Muslim client, where not every county in Georgia is going to be particularly kind.
Let's not say the county, by the way. Let's be even, look at this. I am being more cautious than you.
Which is never the case.
No. So let's not say the county. So this case was filed not by us, by the initial lawyers who then asked us to get involved in a metro Atlanta county, which we wanted to be in a metro Atlanta county because of a lot of reasons. Jury verdicts are higher, judges are good. It fits the demographic for our client, a mix of different ethnicities and demographics for people. What we didn't want to do was go to federal court, which procedurally, meaning like the rules are a little more
stringent.
Yeah, they're annoying. I wouldn't call them more difficult. They're just more annoying. And the case would have a different jury pool, which would be a broader jury pool and include people outside of Metro Atlanta. And we wanted to stay in the Metro Atlanta county where this happened.
So, in order to stay in state court in that county, one thing that we do, and one thing that a lot of folks do when they're suing a corporation, is they find an individual employee or actor who contributed to what happened, was negligent in some way, and they add them as a defendant to the extent that that person lives in the county where they're trying to file the lawsuit. That way you can be in state court because that person lives in that county as opposed to federal court.
We got to give torts 101 here. I guess it's personal jurisdiction 101. So when you sue a corporation, a business that resides, I'm using air quotes here if you're listening to this, resides outside of the state, then when you have two, one is the plaintiff, one is the defendant, and they live in separate states, for the most part, that goes to federal court. For the most part. In a case like this, it does.
Yeah, if you're seeking more than $75,000.
Yeah, and depending on what state you sued, but we don't need to get in the nitty-gritty, but that's the idea. If you, the plaintiff, who live in Georgia, sue someone, though, who resides in Georgia, it has to stay in Georgia state court. So what do? Well, if you sue the company, you're not going to be able to stay in Georgia state court. So you go find an employee who is responsible for, in some way, what happened, and here it was the store manager. We sued the store manager who lives in Georgia in that county, and we did that because the store manager was involved in the sense that store policies and procedures were not followed, and that keeps the case in state court. Now, if you're saying lawyers are assholes, screw personal injury lawyers, how would you ever, why would you sue this poor individual guy? It doesn't matter to him. Yes, he was sued in name, but in reality, he's defended by the employer, the store's lawyers. He doesn't owe any money. He doesn't have to pay anyone. He would never have to pay a judgment. It's purely a procedural thing to make sure that we end up where we want to end up. And it's allowed. You might be thinking, this is ridiculous. This is, if you're little knowledge about this, it's called forum shopping. Yeah, it is. And it's permissible, allowed forum shopping. We're choosing the forum, the place we want to have this lawsuit.
And the person that was added as a defendant initially was the store manager. But as we learned in the case, they were not the store manager working at the time of the fall.
Well, tell everybody the really fancy way we figure out store managers at stores. Now, be careful about how you describe this.
In some stores,
Okay. Oh, gosh. There's a wall of photos.
There's a wall of photos identifying who a manager may be.
Yeah. So that's the fancy way we find out who the manager is, because it's there. But we were 2 years, I wouldn't say we were late, but we got involved
Right.
2 years after this, so things had changed a little bit, and we found that out.
And we learned that who the correct store manager was.
Yeah, so then we had to swap them.
Right.
And once we swapped them, we were able to stay in state court, which is what we wanted to do.
But
I know there's a middle here. I know there's a middle.
Okay.
Go ahead. No, go.
The middle is we agreed that the first store manager should be dismissed.
Yeah.
But then we asked the court to substitute the proper store manager. And we did it in a way that was 2 separate motions, and I will never do that again, even though I think that was fine to do. The judge saw one of them before she saw the other one and granted the dismissal before she granted the substitution. And so for like 3 days, there was a brief moment where the only defendant was an out-of-state company. And so the lawyers for the store,
Who do not want to be named.
who do
This is good
not
work
want to
they
be
did. This was good work by them, though.
well, the judge didn't like it.
Petty, but good work.
Yeah. Removed it to federal court, meaning they took the case that had been filed in state court that had the right people to be in state court in it and said, you don't have those people anymore. You're in federal court. This is going to benefit us. Now,
Even though they had agreed to swap the store managers.
correct.
Yeah.
When we got to federal court, we had to file something pretty immediately to try and get this correct store manager back into the case and hopefully go
Back to state court.
Back to state court.
Yeah.
We filed that motion, and the judge did not like what the store had done.
Yeah. Because they had agreed with us, yeah, well, you can swap the people. And then they saw this little opening that was completely contrary to the agreement that we had come to. And yeah, I mean, it was obvious that they had done something dirty. I think she criticized the way that they handled this situation.
Correct.
And creating a situation out of nothing. But I mean, I remember them, kind of arrogantly telling us, no, we're going to be in federal court. You guys, the value of your case just went down. Right. And I remember us saying like, no, this isn't going to go that way.
So we're back in state court where we wanted to be, and we've got the right manager.
Yeah. So then the case kind of actually begins then. And one of the biggest hurdles and one of the first hurdles is we're now in state court. Where we think we know the judge. The problem was that that judge was elected to a different position. Mm-hmm. So for a while there, we didn't know who our judge was. And there's a motion pending that the defense had filed, which is called the motion for summary judgment. And that motion for summary judgment said that they didn't do anything wrong. They said, hey, we don't need to talk about this death, the surgeries, the injuries at all. Look at the video. This was their argument. Look at the video. We didn't do anything wrong. They filed a motion that said that. And look, if you can't prove that something wrong happened, you lose. So we had to defend that. And I guess the starting point probably to talk about that would be the sweep log. So will you explain what a sweep log is without violating the confidentiality? By the way, if the best part about this is I keep putting the ball in your court, if you notice. Every single time that I'm like, hey, here, say this, but don't violate the confidentiality. I'm like, you, because I can't be trusted.
Oh, you certainly can't be trusted.
No. So I recognize that, but at the same time, like, there's a lot of pressure on you.
We've talked about this before. My role is to just make you take a little bit step back and think about things just a tiny bit more. And if I've done that, I think we can have a successful firm. When this motion for summary judgment, all we have to do is we have to point to one thing that a jury could think the store and its employees did wrong.
That caused the
fall. One thing. If there's, and it's not definitive. We don't have to prove that one thing happened. We just have to show that a reasonable juror could conclude that.
If they believe everything we say, that's the key, right? Everything is assumed to be in our favor at this stage.
And as we talked to people who worked at the store, there was a rule that they had that you have to sweep the floors every 2 hours. Sometimes other employees said, we were told to sweep the floor every 45 minutes. But the longest period of time we had was 2 hours. And during the case, we got this log of all the sweeps that the store employees had to do. Our fall happened around 10 o'clock at night. And this sweep log said the last sweep happened around 6:30. So by anybody's standards.
And a sweep is you take a big ass broom and you put it on the ground and you touch everywhere. Because if there's a spill or something, you will run it over. You'll run through.
It's like, everybody had that gym teacher who has the giant broom that they're like sweeping up and using on the basketball court, like while you're a kid and sitting there and you have to get up for it. That's what they're supposed to use.
I think about a Zamboni. That's what I think about.
It's, that's like the...
It's like the North.
Broom is on one end and Zamboni's on the other. This broom, this sweeper, I guess, or mop is kind of in the middle.
No, that's good. The gym guy's good. I may use that in the future at some point. Yeah.
The reason why they have to do these sweeps is because it picks up things on the floor that have been spilled.
And there's a I wouldn't say a law, but there's a understanding in Georgia that if something's on the floor for more than, depending on who you ask, either 10 or 15 minutes, that it's presumed that the store or whoever it is that has the spill, that they could have known about it and that they probably should have known about it.
Right.
And here, what's the math there? 3.5 hours?
Right. No person told us a time period where that was an acceptable amount of time for them not to sweep the floor.
Well, and the other overarching problem of, I think we interviewed 4 people. We deposed. We had depositions of 4 different store employees that I can at least think of, and all of them said different times. Like, what is your rule? We don't know. It's something like this. And we were giving them the benefit of the doubt. I mean, there was the one who said every 45 minutes.
Right.
So we were trying to give them the benefit of the doubt on every 2 hours.
If the jury is presented with information that you're supposed to do a sweep every 45 minutes, or you're supposed to do it every hour, or you're supposed to do it every 2 hours, and then they see a log that shows that nothing was done for 3.5 hours before this, well, that's enough to survive summary judgment. And that's what we did here.
Well, were you there?
I argued it.
Did you?
Yeah.
Oh, yeah, you did. Yeah. Oh, wait, hold on. This is a good story. I forgot. So we go to the court. It's their motion, so they go first. They explain why, and that's the first time that lawyer said that blame the kid. Do you remember blaming the kid?
Yes.
So we'll have to show the video. We'll have to cut the video of what they say is the kid throwing milk or something, which I remember being in court. Look, I'm not criticizing you in any way, but that's 2018, early 2019? Mm-hmm. How long had you been a lawyer for?
About 2 years.
Yeah, and I thought the motion was a layup. I thought we were going to win very easily because they hadn't done a sweep. Here's the video. We should win.
I appreciate your confidence.
And so it went. So I was like, you should handle it.
Yeah.
Is that how you remember it?
That is how I remember.
Okay. And I remember though that is not how it went.
Yeah. The how it went was
because the other lawyer blames this kid, and we're like, what are you talking about? And then the judge made a comment like, this is a really close call. And I remember being like, my clenched and I was very nervous.
Yeah.
That's the truth.
I mean, it was not a close call if you'd looked at the video 1,000 times and had gotten into a certain frame of mind, which now we have to, every time we have a motion like that, we have to look more at it, or we have to look at it more from the defendant's perspective. But we won, and I think we should have won, and I don't think that there's any world in which that case shouldn't go to a jury on how the fall happened.
No, I agree, but if you would have lost that,
we wouldn't be sitting here.
No, I'd be sitting here maybe, but I don't know if you
wouldn't be talking about this case.
I'll make a little side note here is that a lot of being a plaintiff's lawyer is really challenging and really fun. Like we have a lot of fun doing our job, but if you lose something, like it's the worst feeling in the world for so many reasons because you lost the case, you screwed up for the clients. Maybe you didn't screw up. You lost the case, you lost for the client, you lost your time and money invested, you're personally embarrassed. Like Our job is not the place to come and be a young lawyer like you were and make mistakes. Like, it's not a great learning place like that you learn through mistakes.
No.
You learn through mistakes. Like, you're not going to keep working here. You can't.
Your mistakes, and some people who have firms where they start out and if they make the wrong mistake too early, their firm is done because they don't have any money to continue.
Right. You know, I want people to make sure they get the right idea. You were the best person to handle that motion because you at that point had watched the videos 1,000 times
from every angle.
Yeah. I mean, your job was, hey, focus on this and solve this problem of how the fall happened and learn everything we can. And we knew we had photos from that the store had taken showing, I always thought it was mayonnaise or yogurt, but anyway, so we had those. Like, we knew there was something on the floor and all that, but you know, your job was to do that, and you were the best person to do it. You were better equipped to do it at that moment than me. If we wouldn't have won the motion, it would have had nothing to do with your performance or mine. It would have been that, you know, somehow we got a bad ruling. We probably would have appealed.
Right.
But what I would be worried about for people out there is I read a LinkedIn post the other day, actually, where this guy was like talking about his first trial, and he listed in this long ass post of all the things he did that were bad, that he screwed up. And he ended with, you know, like, I'm the reason that I lost the case. And I feel, you know, like I will always try to be better. And I'm like, dude, like, you did all these things wrong and you lost the case. Like, this isn't like a learning moment for you. Like, cool, you get to learn, but you lost for your client.
Right.
Like, our job is not the place to learn at the sake or at the expense of clients.
No.
And that's why it's a really stressful, tough job. Yeah. So thanks for not losing.
Yeah.
Yeah, I'm glad you're here.
You know, our client in this case was the surviving spouse of the person who passed away after the fall. She was always such a great client, but losing this case for her would have been personally devastating to me in a way that I have never experienced in my career. Thank goodness. There are those clients that make you want to work the case really freaking hard for 6 years, and she's that person.
And then there's clients where you just don't mesh with them, or, you know, they aren't people that you're going to prop up on a pedestal and kind of, you know, and that's going to be your motivation. Then otherwise your motivation has to be something different, which I always have a motivation in a case, multiple, but it's either, you know, I want to win because no one says I can. I want to win because this is going to be very valuable. The client isn't always the number one reason. That'd be ridiculous to think of, that it's always like, there's a lawyer who lives right there across the street. We can actually see his house from mine. You're looking at your head down in shame. There's no confidentiality on him. I could say his name, but he lives right there. Any case that I'm in with him, I don't care who it is. He's my motivation. Right. I want to beat him into the ground. Like, he's my motivation.
We know.
And there's nothing wrong with that. Like, that's my point. It's not always going to be the client, right, because not all your clients are the most sympathetic, saddest stories in the world.
Right.
Like, that's a good thing.
Right.
That's a really good thing. All right, we got to talk about, let's talk about mediation. So we survived the summary judgment. When we say survive, meaning the case goes on. And it was the first mediation in this case and the first COVID mediation we ever did.
I believe so.
Yeah.
Via Zoom. And now we do all of our mediations via Zoom because
love it.
It's much better and we can work on things.
I don't wear pants. I didn't
need to know that.
But oh, yeah, just saying.
The second mediation in this case was also via Zoom.
Yeah, so the first one was nonsense, though.
The first one,
I don't think we can say the numbers in the first one.
Right.
But the first one, we were offered so little that we were both angry that the mediation was suggested by the store and their lawyers. And when a store or their lawyers come to you and are like, hey, we'd like to mediate, what that means is we'd like to offer you money. Like, that's always cool. Thank you. But they had a really good idea of what we wanted for the case at that point. Mm-hmm. And it was much lower than $7.75 million. Much lower. Because at that point, we have still all these issues. We don't know if the jury's going to believe that the fall was the reason that our client needed the first surgery. We don't know if the jury's going to say that our client was the reason he fell. We don't know if the jury's going to blame the store. We have all these challenges.
And we especially did not know whether the jury was going to connect the dots between, could that fall cause someone to die?
Yeah.
And that was going to be a significant burden for us at trial of, okay, we can talk about it now of fall, all the treatment that you could possibly think of before you have a surgery. You have a surgery, you need a second one, and then you die from complications of it. Now that we're on this end of things, we can create that, timeline in a podcast. But having a jury see the defendants in the courtroom and say, I think that mayonnaise or pudding or whatever it is on the floor of the store caused this person to die, and the store should be responsible for the value of that person's life. We struggled with that a lot.
Yeah. I was definitely willing to settle the case for $1 million or a little over $1 million.
Back then.
Yeah, back then. That was 2020.
Yes.
Yeah. And we were not offered anything like that.
We were not offered our client's medical bills.
Yeah. Because being in the hospital for those 2 surgeries racked up medical bills. Even though he passed away, his estate was responsible for paying back those medical bills.
Correct.
So we were essentially offered zero in real dollars. Like after everything gets paid, medical bills and all that, like I remember leaving that mediation and then I probably went and smoked a couple cigars. But I remember at some point we reconvened, me and you, and I was questioning whether we were just totally wrong on the valuation.
Yeah.
Like they offered so little money that I was worried that we were just so wrong. Because by that point, either we were right and they were completely wrong, or the reverse. And I was like, is it us?
Post the start of COVID in 2020 was a time for everyone to already be in their head about whatever things were going on.
No idea when there's going to be a trial.
This did not help us. We were in our head about what happened at this mediation and why we were thinking about this case wrong. And I think for a few days we had convinced ourselves, like, we must be missing something huge. There must be some bombshell that's going to come out at some point. And it never did.
Yeah, so what we did, and we had been doing this through the time, is our job was to connect the dots. We need to say step 1, step 2, step 3, step 4 in the medical treatment. So that's what we started doing. We went, all those doctors that we talked about earlier, the first opinion, second opinion, third opinion, he actually got to a fourth opinion, because contrary to what most people would think, an injured person that when we are helping someone, most times they're getting second, third, and fourth opinions to not have surgery. It's not that they're trying to run around saying, I need this treatment, it'll help my case. They're trying to not have surgery.
There are lawyers that will tell their clients that they need to get a surgery, and that dumbfounds me.
Yeah.
Our conversations with our clients are, I can't tell you what to do with your health and your body. I mean, my recommendation is this. If your doctor says you need something,
Do it.
Do it. If you have pause about doing that thing, go talk to another doctor. And what we never do is we never say, okay, go to this doctor that we have a relationship with. Because we don't have relationships with those doctors. And so our job is to see what doctor our client is treating with, hopefully through their health insurance, and say, this person is good. I know of this person. So
They're at a good place.
They're at a good place. I'm not a doctor. I don't know if that recommendation is good, but at least I know they're in a good place.
Now, we can tell you who not to go to, because everybody knows who bad, in any industry, it's easy to say who the bad people are, the really bad people, because they've been sued.
There are some doctor deaths out there.
Yeah. So this was you, connecting the dots, going to Dr. 1 saying, what did you tell our client? What did he do? Okay. How did he get to Dr. 2? Okay, Dr. 2, what did you tell him? What did our client tell you? How did you treat him? And you were connecting the dots step by step, so that way we had a story to tell the jury. It did make sense, but it was a difficult story to tell.
Yeah.
How many depositions did you do of doctors?
I think 9 or 10.
Yeah.
All the doctors that our client went to, that includes some physical therapists.
Yeah, we got if you're living and breathing, we wanted to ask you.
And it also includes some of the doctors that the defendant hired to rebut what our doctors were saying, to try and create that gap between the fall and whether those surgeries were needed or not.
So they had a orthopedic surgeon who basically said, yeah, your client fell. He was probably hurt, but he wouldn't have been hurt for very long, and he wasn't hurt very severely. So after a couple weeks, he would have been okay. That was basically his testimony.
Yes.
And then my favorite part of their experts is the expert who wasn't an expert, wasn't allowed to be an expert. I guess we can't say her. I don't know if we can say her name. Can I say her name?
We don't need to.
Man, come on. Come on.
Take a step back.
Oh, this is awful. This is awful. God. All right. So there are certain deadlines in a lawsuit, and in state court, most of those deadlines don't mean anything. That's the truth of it. In federal court, deadlines really mean something. Like, you don't miss federal court deadlines.
Right.
But in state court, things kind of ebb and flow, and that's good for some situations, not so great for others. But well after this deadline, they decided to add another expert, who would say,
there was medical malpractice.
Finally. And that was 5 years?
5 years into the case.
So we've been sitting around for 5 years being like, wow, this is medical malpractice. Well, that's what I was saying. You were saying, what was your nonsense again about why it wasn't medical malpractice?
I just didn't think that it was.
Oh, man. All right. So anyway, you all know my opinion now. But and let me pause and turn to the camera and say, though, just because it was medical malpractice doesn't mean that the store is not responsible, because our client wouldn't have needed that surgery and the doctor wouldn't have messed it up, in my opinion, in some way. I don't know how. Then none of that would have happened if he didn't fall at the store and if they would have swept the floors.
That's what the law says.
Yeah.
And our problem with that and our fear about the medical malpractice part of this case, to the extent that medical malpractice was injected into it, was, would a jury believe that? We've already got the problem of, are they going to believe that this death was caused by this fall that they can see in the video?
Or are they even going to want to blame the store? Because that's right. Not, people aren't falling and then dying on a regular basis.
It's hard to ask a jury to say, I'm going to blame this person for something that someone else did just because someone else came after the original defendant.
Yeah, I mean, the classic example in our state, at least this one, is that you get into a car crash, you get put into the back of an ambulance, and while you're driving in the ambulance to the hospital, or somebody's driving you, and you're in the back of the ambulance, that ambulance crashes. That's a result of the car crash.
Right.
But that's what the law says. Sure, that's great. The practical problem is the jury going to go, you know what? Like, we would have asked for more than $10 million in this case.
Yes.
at a trial. Is the jury just going to go, I'm never going to award $10 million against this store because they're not responsible for all of it, even though the law says they are. I can't do it. And that was always our fear. Mm-hmm. After this deadline, they go and they hire an expert who finally, for the first time on their side, says this is medical malpractice. And we learn that in the 5 years we've been worried about this, the 5 years we've been stressed about it, the 5 years we've been taking every deposition and kind of like trying to get in there that this wasn't medical malpractice in a discreet but, a way that doesn't scream from the rooftops we think it's medical malpractice, but also gets our point in. Finally they come out, and we've learned the whole time it wasn't even on their mind. Never even crossed their mind this was medical malpractice, which is wild.
The way that this came out is one of the defense lawyers encountered a condition that our client had in one of his relatives.
Yeah, a family member of his was sick.
A family member of his was sick, and he said, wait a minute, that's the same diagnosis that one of the clients in my case has. And so he asked the doctor about it, and the doctor said, oh, you might want to have somebody take a look at that.
When I like visualize this, I think of him like being at the hospital, and this I think is what happened. He's talking to the doctor about his family member, and then like in the back of his mind, he's like, hey, by the way, let me ask you this about this case. And I imagine like his conversation takes a left turn, but that happened in early December of whatever the heck year. And by the end of December, he had gone and hired an expert and was now claiming it was medical malpractice for the first time 5 years later.
Right.
And we went to the judge and said, hey, too late, which is a really tough argument. It's really tough. The judges don't want people to be just too late. They want you to have a reason why, and a really compelling reason why too late matters. Well, and we did. We did. Our reason was everything had already been done. Right. We would have had to go back to all the 9 depositions, all the other things that we had done. We would have had to go back to every doctor and say, hey, they now say this is medical malpractice. Do you say it's medical malpractice, and why not?
the standard is really, is it fair?
Yeah, and wasn't fair.
And if it boils down to that, there are 5 factors, and if we went through that in a podcast, they would put people to sleep.
Yeah,
it's if you
can we keep them confidential? Let's keep the 5 factors confidential during this whole thing.
5 factors confidential. But are we prejudiced? Are we disadvantaged by the fact that they disclosed this doctor late? And it's not like, okay, well, you're disadvantaged because now you have to spend time going to depose this doctor. It's okay, well, we would have to depose 9 doctors and get all their testimony all over again. We would also have to litigate all these issues that we've been litigating for 5 years with this new defense in mind.
How long do you think it would have taken to do those 9 depositions? Just purely by scheduling. Like how long does that take? 6 months? 8 months?
Nightmare. Yeah.
I mean, that's how long that would take. And then we're doubling our costs. Which, yeah, we pay for them ourselves, and we wouldn't be particularly disadvantaged, thankfully, that we can afford doubling the cost of this case. But our client eventually foots the bill at the end, and that shouldn't be put on her.
Right. Especially considering that this was all preventable if the defendant had just determined this was one of their defenses and that they were going to point to medical malpractice earlier in the case, before the deadline.
Being both of us have been defense lawyers, I can't imagine being on that side. You realize 5 years into this thing, as the defense lawyer, you say to yourself, wow, this could be medical malpractice. And you've been working on the case for 5 years and you've never thought of that. And you've never brought it up to anyone. I don't know how you go to your client, the store, if you're on that side, and go, hey, I had this bright idea 5 years into it. Should have thought about, do you say like, I guess I could have thought about this 5 years ago, but yeah, I think it's medical malpractice and we should argue this. If you're the client, if you're the store or the store's insurance companies, aren't you like, what
are you even doing?
I'm losing confidence in my defense team. I mean, that would be really scary. And I don't know how that was viewed. That lawyer who came up with that idea was eventually, shortly after, removed from the case, from the defense side.
Yeah.
So I always wonder if those are connected where, he has this idea, which good for him. There were other lawyers on the case too. They didn't have the idea either, but he gets removed from the case, and stayed at the firm. It wasn't like he left the firm and that's why he was removed. He was removed from the case and we got a different lead lawyer.
Yeah.
I got to say, this isn't confidential. So then like the case settles and 3 days later, that lawyer announces he's going to a different firm. I'm just saying, like I got my conspiracy hat on here today. I'm just saying those things don't add up, or they do add up perfectly for what I think, which is they realized, wow, he did a really bad job. And then the case settles and then kindly leaves her. The door is that way. Don't let the exit hit you on the way out.
Yeah.
Yeah. You agree.
Moving on.
All right, we got to wrap this up and talk about the actual settlement and how that worked.
Yeah.
So we had a second mediation.
We have a new lawyer.
A new defense lawyer.
In the case who calls us and
out of the blue,
we're ready to try this case.
And he's like, hey, I've looked at this with fresh eyes. And I think I see where you all think the value is and we should mediate the case. And we said no.
We've heard this before.
Yeah.
From these same people.
Yeah, so I guess it's important to say, after that first failed mediation, the case for us keeps getting better. We keep winning things. Judge keeps ruling in our favor. We keep getting good expert testimony. We keep getting good witness testimony. Like the case is getting better every year.
And so when you said earlier, hey, this lawyer was messing up on the defense side, we were the cause of that.
Oh, yeah.
We caused all of this to happen. And through motion, through hearing, we just kept winning on issues that I know we should have won. But we just kept winning and we kept trying to narrow the issues down in a strategic way over time until there was nothing left for them.
I think, pat yourself on the back, I think we did a really good job of taking the issues and, all right, we'll file a motion here that moves this wall in. We'll file a motion here that moves this wall in. And sometimes, in some cases, we wouldn't have done that. But in this one, as much as I wanted to try the case, and I always thought we would, I wanted to make sure we couldn't settle this case because I was really worried and was always worried about what the jury would do to value of a slip and fall in a store like this where they weren't the direct cause of the death. So this is one of the few cases I want to try every case, but this is one of the few that I was like, we need to figure out if we can settle it. We have to figure that out. So we kept closing the walls in on them.
And one of the things we talk about all the time before mediations or trying to settle cases with our clients is, are they giving us a tough decision?
Yeah.
Are they giving us a number that it's really hard for us to turn down because of all those unknowns, because of all those risks? Up to this point, when we got that call, there was absolutely no risk.
Over the years, I had said to them, we would go back and mediate if you pay for the mediation, which I didn't really care about. You put $1 million on the table to start, and then we would mediate. And I remember at one point they asked the judge to order us to mediate a second mediation. And I said, no, we've already done this. And here I shared with the judge, I said, here's what we want to mediate. And they said no.
And she said,
yeah,
I agree with the plaintiffs.
Yeah.
For the seventh time in the case.
Yeah. So there were there were long periods of time where they're essentially fighting to get us back to mediation, with the idea being, my fear was, right, they put a number that we don't love, that we don't really like, but our client is like, okay, yeah, I'll take that. And no one's feeling good about that. We didn't want to put our client in that situation. We wanted to be in a situation where we know we have a really good idea, at least, that we're going to be in a number that we really like.
Right.
So with that said, though, I mean, even putting $1 million on the table with the number we wanted, settle for $7.75 million. I can tell everybody in the world we wanted 10, we wanted 15. Yeah, of course we did, but we would have taken less than $7.75 million.
I don't know.
Oh, bullshit. Dude, you want to do the game now? Let's do the game. All right. Well, so do you take, no. We
had the opportunity to take an amount that was very similar.
Do you take right. Well, all right, hold on. Before we kill each other, let me walk through the mediation and explain why we didn't take it. I'll be honest and tell everybody.
Okay.
They call us up, I guess, a month before, and they go, we'll offer you $1 million. Will you still mediate? And I didn't want to, but I had put my word 3 years earlier that if they did that, I would mediate. Right. So I said yes. Right? We call it to our client. Client goes, yeah, sure. And we do it. We get through mediation, which was actually pretty quick. It was only a couple hours. And they say, this is our offer. Will you take it? And that number is significantly less than 7.75, but in a range we would accept. Is that right?
I disagree. But
well, it was a number that if they told us this is our absolute best and final, we really would have struggled. Is that fair to say?
Yeah, we would have struggled. But I think that we would have tried that case for. I think we always, before a mediation, we have a range of, this is what gives us pause. This is a 100% we take it.
Yeah, green light, yellow light, red light. Exactly. And this was in the yellow light.
I don't remember it being in the yellow light.
All right, maybe I got it wrong. Maybe I just want to make myself feel better.
I think if we want to talk about the good job that we did at the mediation, we got them to move from the yellow light to the green light after the mediation, because we said we're not taking.
Well, one of the most important things that didn't happen at the mediation is when they give, and their number I think was like 6, right?
Yeah.
All right. So they tell us whatever the number was, 6, let's call it. I don't remember exactly what it was off the top of my head. But at the end of the mediation, or the mediation ends by them saying, will you accept 6? And we say no. And what didn't happen is they didn't say, this is the best and final, this is the last dollar you're ever going to get, this is our highest offer, you better take it now. Mm-hmm. They didn't say that, which to me means there's still more money. So that's why, I mean, it's like poker. We weren't playing our cards at that point. We were playing the man. And the man holding the cards wasn't telling us, this is it. And so we spent, another week or 2?
Yeah, about 2 weeks.
Continuing to negotiate through the mediator, right?
You continued to negotiate while I was getting ready for trial, because
I was already ready. You gotta get prepared. You're last minute Stokes. Yeah, I was already ready.
I don't agree with that.
I didn't need to do anything. I was ready.
And this is what you've told me, so I hope this is true, is that, and this makes sense.
Oh, it's like I didn't want to tell you.
You didn't want to tell me because you didn't want us to stop preparing. It's like when we go to trial, we try to have somebody that's making all the settlement decisions, and it's typically somebody that is not going to do the closing argument. Because if you're trying to do a closing argument and you're trying to negotiate any settlement offers that the defense is hurling your way at the last minute, then you're distracted.
Yeah, you're in your own head.
And so we kind of felt that we were so close to trial and we knew when it was going to happen that it didn't make sense for both of us to be in, hey, this might settle mode. We needed to have that divide of, it's just as likely that it settles as it is that we have to go try the case.
And it couldn't have been you negotiating, because if you wouldn't have been getting ready, you never would have been, because you're last minute Chris.
Okay. I've done a lot of great work at the last minute.
But you're last minute Chris. You've gotten better, and it used to stress the shit out of me. I've learned to accept it to some degree. Yeah. But yeah, so then eventually the mediator calls and asks, and says, he asked me, he's like, how much do you think they're offering? And I said a number. I said 7. And he goes, more. And I said to him out loud, I said, no way is what I said. And part because I never thought they would offer that much more, and it was a weird negotiation, because 6 or whatever the number was, I think was on our verge of we maybe would have taken it. You say we wouldn't have. We're not telling two different stories. That's a discussion we would have kept having and made a decision.
Probably an argument we would have had
with the client. Well, but we would have come to a consensus with each other, and then we would have went to the client and presented it and see what, and have her give her input, and then we would have had a decision made. That's how we go about decisions. If our answer was no, we weren't going to take that lower number. I didn't love the idea of them coming up a little bit and then us having to make a harder decision. Oh, you won't take 6? All right, what about 6 1/4? What about 6 1/2? What about 6 3/4? Like, I don't want to do that. You either want the decision to be so easy that you just go, no, we're good, or so easy that you say yes. And I was stunned that this was a decision. I thought that the yes was so easy, because I don't think more than 50% of the time we get more than this at trial.
Right.
The defense lawyer is probably going to watch this, but that doesn't mean it was a bad settlement on their part, because this could have been a $20 million verdict. I would put that at 1 out of 100.
Yeah.
Maybe 1 out of 100. This also could have been a 2, 3, 4, 5 million. I would put that at 60%, 70% of the time that we're below 5 million. That's what I think. You disagree with you. Disagree.
But at the end of the day, that's why it's important to have multiple perspectives on the same case, because throughout this case, and this is kind of wrapping things up, we had so many strategic moves that we made. We tried to make them at the right time, where, like you said, we're boxing people in on this side and then we're boxing them in on the other side. We talked about that and we argued about what the best move was, and we arrived at that decision together from totally different perspectives in almost every instance.
It's
and
cool.
That's what made it successful, is we thought about this case so much over so long and the strategy of it that eventually the money came.
Well, it's so cool. From a work relationship kind of thing, is on Friday we got, in another case, somebody sent us something, and unbeknownst to each other, I sent you an email, I guess, eventually, that said, like, hey, here's what I did. And you said to me, I already did all this and it's already done.
And we had also both typed out the same email to the defense lawyer, and then both had individually decided not to send it strategically. So I guess over the last 7 years, 6, 7 years,
I have no concept of time. However long you've worked here,
become fewer.
Yeah.
But probably based on a lot of the successes we've had in a case like this.
Yeah. So if there's any takeaway from this, if you're a lawyer, your takeaway from this should be that it's a constant discussion in your head or with somebody else about how to win a case. And there is no perfect answer. You could just do what you think is best and then deal with whatever the next steps are. If you're not a lawyer and you're watching this because you're interested, that's awesome. Appreciate it. I think your takeaway should be that there is no right answer to how much a case is worth. You need lawyers who believe in you and believe in your case and are willing to take risks for you, and want to put you first. Because I think that's what, in the end of the day, I think whether we got our client $1 million or $5 million or $7.75 million, I think that she knows we care about her, and that's awesome. I think you're her favorite person in the world.
She's one of my favorite people in the world.
Yeah. And that was true before the settlement. I want to be clear about that. Like, it's easy to be somebody's favorite person in the world when you give them a check for millions of dollars. But before that, you were her favorite person.
And one measure of success on a case that I did not know until this one was if a client comes to you and says, well, this isn't the end. Like, we're going to keep talking and you're going to stay in touch, right? That's a victory lap that I got to take in this one and that you got to take in this one that I've never had before, to this degree, that feels good.
I told her I have podcasts. We have videos. I can't run away. Even if we tried, you're going to find us. I try to be the easiest person to find in the world. So, and she said she would. So, all right. Well, that's podcast number 1.